Hi, everyone. Harry here to talk about the decision by the Third Circuit Court of Appeals, unanimous decision by a panel, including 2 Republican appointees, that Alina Habba may not serve, is not qualified to serve as the acting U.S. attorney for the District of New Jersey. So this really is a decisive rejection of a theory that the administration is trying in several different spots, including, of course, Lindsay Halligan. And it was a very similar line of reasoning that the district court in the Comey and James cases used to bounce Halligan and say she was not qualified. And it's happened in another district, and it's now the administration has tried it one more time, and that is up for consideration. But so far, every court has concluded against the administration's kind of ploy and maneuvers here, and now you have a unanimous decision by a court of appeals. Briefly, that might suggest there's a lot sort of percolating here that the U.S. Supreme Court might step in to decide it. But if all the courts of appeals stay in lockstep, maybe it won't. And in any event, if it would, it wouldn't be for a while. So as of today, Habba is out, and we will see if something similar occurs in the Fourth Circuit with the Lindsay Halligan arguments. Okay, as I've said from the start, it's really kind of complicated interplay of a couple different statutory schemes, but there's a method to the picayune here, which is keeping the administration from doing end runs around an overall scheme that lets them put somebody in temporarily for starters, but really favors the nomination and confirmation of a candidate so that the Senate can do its constitutional duty of passing judgment. And in the case of U.S. attorneys, that's even constitutionally grounded more than just advice and consent, because U.S. attorneys are inferior officers, and the Constitution says Congress can decide how inferior officers are chosen. An important point to note about Habba is the court, in taking up the statutory issue, is she qualified, did not dismiss the case in which the claim was brought. So somebody was convicted and said, hey, my conviction should be overturned. Not that different from Comey, because she wasn't legit. And the court said, she's not the only person who signed the indictment. We're not going to dismiss the indictment. And they kept to that kind of regime until now while they decided it. So in other words, it wasn't the case that, they were rolling the dice, as I've suggested could be with Halligan, because the courts had specified, we're not going to dismiss indictments. We're just going to decide on whether she is permitted to be in the position. Now they've decided, and now presumably she is out. And if they continue to have her supervise work, those defendants whose cases she is involved in, at least as trying to, in the same kind of role, acting U.S. attorney, those convictions couldn't stand. 3 basic conclusions by the Court of Appeal. So first, there is a provision that says you get an interim appointment, but only one. And the administration had tried to say you can have them one after the other after the other. The Court of Appeal says, 120-day appointment, and then you can't keep going. So she couldn't be the interim. She also couldn't be, if there's not an interim, what can you do? Well, of course, you can always nominate and confirm, but you can't just call her, make her, as they tried to do, first assistant U.S. attorney, because the provision and the whole scheme says that can only be the person who's already first assistant U.S. attorney. And you can't then become the acting U.S. attorney. At least Habba couldn't. Why not? Because you can't do that to someone who's already been nominated. That's a pretty good example of, who cares? It's so technical, but it isn't really. You nominate someone and they don't make it. You don't want the administration to sort of do an end around of saying, okay, we'll make you acting U.S. attorney and you do whatever you want. Once you've been nominated, you can't become acting U.S. attorney. And the administration argued, well, we pooled her nomination, so it doesn't matter. And the court said, it's never once you've been nominated. And then finally, this other little stratagem they've tried in a couple cases to make her a sort of special attorney exercising all the powers of U.S. attorney also doesn't work because the Federal Vacancy Reform Act says you gotta do it our way. That's the basic idea. You gotta do it our way. All the administration, that means do the interim and then the court appoints, which remember, the court did here and Bondi right away just fired that person. Administrations don't do that, haven't done that in the past, but this is very characteristic in keeping with this administration. They fire them and try to have their will, kicking and screaming about the nerve of the court, trying to appoint someone other than who the president wants. And here we have what's happened is precisely the statutory scheme, and it's the administration that's trying to do the end around. We'll see how they'll try to act. The person that the court put in had been the first assistant. So now that isn't the solution for the administration. Maybe they acquiesce in what the court does, but one thing's clear, they don't have any further possibility. They are at the end of the road of making Habba the U.S. attorney by any other name unless they submit her name to the Senate for confirmation. And with all the water under the bridge, I think that'd be a really hard confirmation. So they pushed back, wanted to resist the scheme, took umbrage at the existence of the scheme, and a unanimous Court of Appeals with 2 Republican appointees said, no, you are exactly wrong, and Alina Habba has no qualifications and no permission to be in that spot. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.